Okay, we'll start now.
Yeah.
It's originating application 381 of 2022, Zipmex Company Limited. Originating application 382 of 2022, Zipmex Private Limited. Originating application 383 of 2022, Zipmex Asia Private Limited. Originating application 384 of 2022, Zipmex Australia Proprietary Limited. And originating application 385 of 2022, PT Zipmex Exchange Indonesia.
Good morning, Mr. Jonathan Tang and Ms. Charlene Wee for the applicants, correct?
Yes, Your Honor. May I please support?
Yes, all right. Let me have Mr. Zoom allocution. So parties are reminded that there is to be no unauthorized photography or recording in any form, and no dissemination of any photographs or recording of these proceedings, and only those counsel or persons notified to the court should be present at each location. Parties should treat these proceedings as they would a physical hearing. All right, Mr. Tang, I've read through the submissions. You can summarize your client's position this morning, please.
Yes, Your Honor. Before we begin, Your Honor, I think perhaps it would be appropriate for us to apologize for the application having been filed on such short notice. We filed it on 14th April, and we thank the court for hearing us so urgently, Your Honor, on this morning. Yes. Your Honor, so very briefly, perhaps I could turn the court to paragraph 8 of the written submissions, and I'll use that as a blueprint for the submissions moving forward.
Yes.
So paragraph 8, Your Honor?
Yes.
Paragraph 8 contains a table of key events that have happened since the last time we were before the court for the sanction applications. So it starts there by saying on 30th March, there were the sanction applications. On 31st March, what we did was extract the orders and lodge them with ACRA. We also carried out certain other corporate actions to fulfill some of the conditions precedent for the SSA. And in the evening of 31st March, we issued completion certificates for Tranche 4 and Tranche 5. Your Honor can see those in the bundle of documents. I'll refer to them later, Your Honor, where necessary. Right. Following that, there was a period of time whereby in early April, the subscriber then came back to us and said, well, we wanted to revise the payment terms of the schemes. So instead of giving 100% back to customer creditors and vendor creditors, the subscriber now wanted to give only 10 cents or 20 cents instead of 100%. Subsequently, on 5th April, Zipmex Asia's director, Mr. Im Wee Lai, Your Honor, I'll just refer to him as Bank because I think it's easier that way. He emailed the subscriber to ask for these terms to be recorded in writing. To this date, we are instructed that the subscriber has not gotten back Bank about this request. Because of these revisions, the two directors of Zipmex Asia then started to look for alternative investment. The reason for this is so that they could either co-share the burden of completing the schemes of arrangement with the subscriber, or even take over the obligations of the scheme of arrangement from the subscriber. So these are meetings that are detailed at in the table on 5th April, 10th April, 11th April. So a total of 5 potential investors were met. 2 of them have not panned out. The other 3 are promising at this stage. On 13th April, we updated the court on the status of the restructuring as directed by the court. And this appears to have triggered a response from the subscriber. Because on 16th April, the subscriber then writes to Zipmex Asia to say that their position was that the SSA had lapsed on the long stop date, which is 31st of March. Your Honor has seen in the affidavits we have filed that we disagree, and we believe that there is no basis for the subscriber to say that the SSA had lapsed on 31st of March 2023. Most notably, the 2 conditions precedent which a subscriber identifies as having not been fulfilled, we say they are either excuses or that the justification is not entirely valid for them to now say that the SSA had lapsed. On 17th April, the subscribers' lawyers in Singapore, Raja and Tan, wrote to us. This is when lawyers started getting involved, Your Honor. On 19th April, we wrote back to Raja and Tan, and this letter is at page 124 of the bundle of documents. If I may just summarize this letter very briefly for the court and for the benefit of creditors. We say, Zipmex Asia that is, say that the SSA subsists. We say in our letter that the subscriber has breached its implied duty to cooperate. We say that the prevention principle applies in that they should not be allowed to rely on their own wrong to now say that this is a breach of the SSA or that the SSA has slept. We say that their refusal to take the necessary steps to complete the conditions precedents have set time under the SSA at large. And so this founds our position that the SSA subsists and that we demanded immediate performance of all acts required under the SSA to enable completion of the SSA. Now, Your Honor, perhaps if I can take one step back, I should also say that on 16th April, when the subscriber wrote to Zipmex Asia, they demanded immediate repayment of the sum of USD 4.6 million, which were the sums extended to Zipmex Asia for working capital under the super priority provisions and the super priority order granted by the court. So coming back to 19th April, we wrote 19th April. We have not received a response from Raja and Tan as at the date of this hearing. I am not sure if the subscriber solicitors are attending this hearing. Be that as it may, they are not panelists. So I take that as confirmation that they are not attending. I haven't heard from them as to whether or not they will be attending today's hearing.
All right.
Yes, Your Honor. Well, that is the brief factual summary of what has happened since we last appeared before the court on 30th of March. Now, if I may, I wish to go on to why we need the extension, Your Honor. We have asked for a 2 months extension. This is a very short extension of the moratorium. And this is because there are two possibilities as to what can happen moving forward. The last stated position is in our letter of 19 April. One possibility, albeit at this point it might be remote, is that parties can resolve their differences and the subscriber completes the SSA on the original terms. Of course, that would be the preferred outcome for both the company, the group, and the creditors. Your Honor, is as we set out in the affidavits, there are potential investors that could possibly pick up the shortfall from the current subscriber, right? One of these potential investors, as Your Honor can see, is Blue Square Capital. And we apologize for the letter from Blue Square Capital being annexed to the submissions. And this is because it came in after our 25th, 26th, and 27th affidavit. So we didn't want to file one more affidavit. But we will take steps to file a further affidavit if required to put this before the court. Your Honor can see at Annex A that Blue Square Capital had on 19th April in the evening sent a letter indicating an interest in reigniting the discussions. I say reigniting because Blue Square Capital was one of the initial 3 proposals that were before the court in the 3rd affidavit, I believe, at the inception of these proceedings. We had chosen, or Zipmex Asia had chosen to go with the current subscriber because the terms were more favorable and the return to creditors was more favorable. But at this point in time, we are looking around and Blue Square has reignited their interest. In addition to that, there's also a listed company and a financial institution that are promising leads at this point. While this is not in any affidavits, we are instructed late last night that there's going to be a further meeting this afternoon between directors of Zipmex Asia as well as these potential investors, and hopefully something will come out of that. We are seeking 2 months, Your Honor, so that we can further explore these possibilities and find a more definitive outcome for the benefit of creditors. We appreciate that the prospect right now is vague, and hence this is why we are only asking for 2 months. And if there is a resolution or if there are any material updates, we'll come before the court further on within the 2 months to update the court as to how this restructuring is progressing and what the planned prospects are. If I may go on to address the court on why the moratorium protection is needed. Yes, Your Honor. As Your Honor has seen, the subscriber now has a claim for USD 4.6 million in its letter of 16th April to Zipmex Asia. The subscriber is a secured creditor because the 4.6 million is secured by charges granted over Zipmex Asia's shareholding in Zipmex Company Limited, which is Zipmex Thailand, and PT Zipmex Exchange Indonesia, which is Zipmex Indonesia. Now, these are also applicants in the moratorium proceedings before Your Honor. If the moratorium is not extended, Your Honor, there is the chance, and a very real chance, that the subscriber will take the view that is entitled to enforce upon the security and sell the shares. These will have debilitating consequences, we feel, for the Zipmex Group, because we are presenting the group restructuring as a holistic group restructuring. And in addition, the bulk of the value of the group and its attraction to potential investors lies in Zipmex Asia, Zipmex Thailand, and Zipmex Indonesia, Your Honor. So the moratorium protection is very necessary in order to ensure that the group has at least a prospect of being successfully restructured through potential investment or otherwise. The grant of the security pursuant to the super priority orders means that the subscriber potentially can bypass any litigation threat. And even if it is later found that our position, as in our 19th April letter, is correct, by the time the damage would have been done, it would be impossible for us to further restructure the group. And this is not something that can be compensated later, either by damages or by an award of costs. Your Honor, those are my substantive submissions on why the moratorium is needed and why an extension of the moratorium is necessary.
All right.
Yes.
All right. Could you go into the sealing applications as well briefly?
Yes, Your Honor. It is not strictly a sealing application, but we feel that we have a duty to inform the court on the current update of the status of the sealing order. Your Honor will recall that previously, when we first filed the 13th affidavit exhibiting the SSA, we had applied under summons 4325 of 2022 for the 13th affidavit of Marcus Lim to be sealed. We are given 4 reasons for that. 1 reason for each of the parties to the SSA. On the company's part, there was this concern about trade-sensitive information being disseminated to the general. The 2 individuals' part, they were concerned for their personal safety because their addresses would be reviewed if the SSA were disseminated. Now, on the subscriber's part, Your Honor has seen an excerpt of an email whereby the subscriber had requested the sealing so that there wouldn't be any undue pressure from members of the public or the media to complete the transaction. Given the subscriber's position in its 16 April letter, I believe we are bound to inform the court that this position or this reason might not necessarily be valid any longer. We are not asking for the sealing order to be discharged, just to be absolutely clear, but we do believe that given developments, if the court were to revisit the sealing order, we are happy to assist the court in coming to a determination on whether the sealing order ought to continue to subsist. And for that, Your Honor, we also recall that at various hearings, Your Honor had always asked us this question: will there be any prejudice to creditors? Our answer back then, every time the court has asked us, is that the unmasking or the masking of the subscriber's name would not result in any prejudice to creditors, because if the SSA was completed, then the creditors would be paid back in full. This might not be the case now, given the position that the subscriber is taking. If the SSA is terminated, then creditors may be minded to seek legal advice as to their recourse, because their expectations under the schemes will now potentially be violated. Any such actions may include some recourse against a subscriber. We are not sure. It depends on the creditor's wherewithal and the creditor's desire as to who to commence proceedings against. But if any creditors do wish to seek advice as against the subscriber, they would necessarily need to know the identity of the subscriber so that counsel can clear context. That's the first thing. The second thing is that because of the masking, the subscriber's identity and its domicile are also unknown. And these are matters that would be considered by creditors and their counsel in deciding how best to proceed. I had mentioned earlier 4 reasons. We say the subscriber's reason is probably at this point no longer valid, but the 2 individuals, we do not have instructions. They are not our clients, right? But we believe that those concerns may still be valid. On the company's part, our instructions are that because of the substantial amount of commercial information that is already set out in the body of affidavits that have been filed later on regarding to the SSA, perhaps the disclosure of the SSA at this point is not as prejudicial as initially feared.
All right.
But at the end of the day, Your Honor, we leave it to the court to determine whether or not the discharge of the sealing order in summons 4325 is appropriate moving forward.
All right, thank you, Mr. Chang. Now, could you let me know what is to happen at the end of the 2 months?
Okay. I think that, okay, earlier I had mentioned that there are 2 possibilities. The first possibility is that at the end of the 2 months, the SSA is completed and we can implement the schemes. That of course, is the, while it might be a little bit pie in the sky, it's still a possibility at this juncture. The second possibility is that we can enter into binding or non-binding term sheets with potential investors to pick up the slack and the shortfall, right? There is an amendment mechanism within the schemes, and the amendment mechanism requires the creditors' meeting to be called. If this is the case, that we are able to secure potential investment to take up the shortfall in payment for creditors, then we can initiate that process. And I anticipate that at least within the month or within the month and a half, and definitely in this particular application, we will be in a position to update the court and request additional extensions of the moratorium if the second set of circumstances pans out and we get alternative investment.
And leaving aside the first possibility of everything going smoothly through the completion of the SFA, isn't it likely that there will be some potential litigation coming up between yourselves and the initial investor?
Yes, Your Honor, and that's why we require the moratorium to be extended so that claims cannot then be brought against the company and the security cannot be.
Yeah, not so much direct impact in that way, but I do wonder whether this will create further complications for your restructuring in terms of the possible returns to investors or a recovery for your investors, your individual creditors.
Yes, Your Honor. I hear the court on the query, and I do believe that any potential investment and the terms of any potential investment will, on the one hand, also provide for the payment of the 4.6 million back to the investor so that that potential liability can be settled, and then we move forward from there. So this is what the directors are negotiating. Again, it is very preliminary at this point. And unfortunately, we are not able to provide further details at this juncture simply because of how fast things have been moving since the 13th of April, Your Honor.
Hold on a moment. All right. All right.
Your Honor, I do have one more matter to address, which is the email from Mr. Dirikwat. And for the benefit of the court and all creditors, we have received the correspondence from court or rather Mr. Direk Kwat, one of the company's creditors, had emailed the court to ask for, to state first that he had no objections to a 2-month extension, but to ask for more stringent reporting details because the company's Facebook and socials have been inactive since 24th of March. Perhaps I can explain why. My instructions are that the Facebook and the socials were inactive because of the lack of payroll for some of the employees of Zipmex Technology Limited who had previously handled these accounts, right? So that has been rectified. My instructions are that as of last night, there has been an update posted on Facebook and socials, and we'll continue to do that forward. But we would also like to say to all creditors that all developments in these proceedings have been put on the company's website, at least, through various announcements. And all scheme creditors, the 70,000 or so who had been dispatched copies of the scheme documents, would have received emails from Kodamenta with updates on what MLS is doing in Singapore, the copies of the affidavits, the applications, as well as all correspondence from the court. So they should be aware.
All right. There's a query on the chat about why does Zipmex need to return the investments. Would you like to address that?
Okay. The query from the creditor was, why does Zipmex need to return the tranche payment since the investor is the one changing his mind? For the creditor's benefit, the tranche payments were paid to Zipmex under the terms of the share subscription agreement, and they are granted super priority, which means that they would only be given to Zipmex if we were able to succeed in giving the investor some kind of security. In this case, it was shares over Zipmex Thailand and Zipmex Indonesia. At this point in time, the investor has the right to liquidate the security. The thing stopping the investor from liquidating the security is the moratorium, specifically paragraph 1D of the moratorium granted to Zipmex Asia back in August 2022. Right. So this is why we are before the court today to ask the court to extend the moratorium to protect the investor, the subscriber from liquidating the shares in Zipmex Thailand and Zipmex Indonesia. The second query that the creditor had was whether we can review the name of the investor.
Thank you, Mr. Tang.
Yes.
All right. Now, in terms, let me take the sealing application. I don't intend to disturb the sealing application in relation, or rather sealing orders in relation to the individuals who needed their identities protected. But in relation to the investor, I think given the circumstances, all right, so there might be a number of questions about the position vis-a-vis the investors and all that. I'm not going to go into that today. What I will invite the applicants to do is to try to address some of these queries directly through your socials or through the emails from Kodamenta. Right now, at this point, my primary concern is just to consider whether or not to grant the extension and what to do about the sealing orders. All right. So, Mr. Tang, could I suggest that I suspect there might be other queries from the account holders that either Kodamenta or the applicants consider some way of engaging with your account holders directly, so you can address it separately, right? But turning back to the question of the sealing applications, as I said, I'm not going to disturb the sealing orders for the individuals involved. But in relation to the potential investor, I will not make any changes for the time being. But what I will do is to ask the company, the applicants to please inform the local solicitors that the court may be minded to lift the sealing in relation to the identity of the investor and other information So could you ask the solicitors to write in within, say, hold on, let me give a specific date. Write in by the 3rd of May to the court if they wish to intervene in some way and maintain the ceiling. All right. So we could do that and just inform the local solicitors accordingly. All right. So
Yes,
for all of you observing the proceedings, I'm not going to change the sealing orders protecting the individuals, but in relation to the potential investor, I want to give an opportunity for the lawyers to come in and raise any concerns if they want to me directly by the 3rd of May. Now, to recap, for those of you who have questions about the SSA and what happens now and the implications of that, I think it's better for the company to engage all of you directly as far as possible through the socials or through some form of town hall if that can be arranged. All right. All right. Now, Mr. Tang, in relation to the extension of the moratoria, what I think I need to signal is that I recognize that many of these cases are complex and that sometimes there will be need to make adjustments and all that, but I cannot continue extending the moratoria indefinitely. Any extension beyond these 2 months, I will require concrete indication of some investment coming in or some improvement in the situation. Otherwise, actually, the better outcome might be to lift the moratoria or let it lapse and see what happens thereafter. I cannot continue to extend the moratoria indefinitely. So something concrete has to come up at the end of 2 months. All right, Mr. Tan?
Yes, Your Honor. Your Honor, in relation to the extension, and this is one thing that perhaps I should have addressed earlier, Mr. Derived had asked for periodic updates every 14 days in his email. We would respectfully seek for updates every 21 days. Just simply, this is more manageable, Your Honor, from the company's cost perspective. And if Your Honor has no objections to that, we would propose that we update creditors through socials, through announcements, and through Cordamenta's emails every 21 days from the date of today for the period of the extended moratorium.
All right. All right. I will accede to that. I think 3 weeks is reasonable. I appreciate that there might be some workload required. So I think anything shorter than 3 weeks might be a bit too burdensome. For the moment, I'll give them the 21 days. If anything, complicated, untoward happens, I will revisit it and see whether a tighter leash is required.
Yes, Your Honor. And probably one more thing as well, monthly management accounts, which, yes, we propose to give monthly management accounts. I believe March is outstanding because, you know, of the way things have panned out. We probably need to give March and April. And we propose to do that in May for March and April.
When in May?
I don't have strict instructions on this,
All
but
right.
perhaps I could propose 5th or 10th of May, either or.
5th of May, I think. All right, by the 5th of May. Monthly management accounts for both March and April to be given by the 5th of May. All right. If you have some insurmountable problems, you may write in, but I think should think that you should be able to do it by the 5th of May. All right?
Yes, sir.
All right. So can the company please update me on the engagement with the creditors on their various queries by 28th of April. All right, so for all of you, I'm leaving it to the company to engage you on some of the queries, but I will want an update from them about what they've done by the 28th of April. And if I see that there's some shortcomings, I may intervene thereafter. All right.
Yes, sir.
All right. All right. So please take back to your clients my concerns about any extension beyond 2 months.
Yes, Your Honor.
All right, and please convey also to the investors solicitors to write in by the 3rd of May if they have any concerns about the lifting of the ceiling orders. All right.
Yes, Your Honor. Thank you for your time today.
All right. Anything further, Mr. Tang?
No, Your Honor.
All right. All right. So for all of you observing, we need to try to move this forward, but my concern is that I cannot extend the moratorium indefinitely. I hope the resolution can be achieved. I hope all of you will be able to get the information required through these mechanisms, but I'm quite sure if they fall short, you'll be letting me know as well. So we will see how things pan out, and I hope for the best. All right, thank you. And otherwise, court is adjourned, and I will. Hold on, sorry. So I will grant the extension. Let me give you a specific date. Sorry, I have not done that. Your primary application is in Zipmex Asia, right? Let me just look at the order.
Yes, Your Honor. It's
EOT.
Step 3 of the BOD.
Sorry, this is 3.1. 104. Hold on a moment. Let me just echo it. All right. Let me give you a specific date instead. '21st, 1, 2, 3, 4, 1, 2, 3. That would have been the 16th of June, was it?
It would have been, but Your Honor, I propose to just use calendar months instead, Your Honor, and request for 21st June for simplicity.
Unfortunately, I may not be available on the 21st of June. All right, I'll give you to the 30th of June. But application for any extension to be made in good time, and we'll work out a date accordingly. All right, so make it as early as possible. All right. Otherwise, order in terms of prayers 1, 2, and 3 of each of the summonses for EOT. All right. All right, Mr. Tang, you clear?
Yes, Your Honor.
All right, thank you. All right.
Thank you. Good day, Your Honor.
Good day. Court is adjourned.
Court is adjourned.